Good afternoon, and welcome to the culmination of Fiduciary September, a month which the Institute has set aside each year for 9 years to underscore the importance of the fiduciary standard with the voices of highly respected leaders in the financial industry. My name is Darren Fogarty, and I am the research analyst at the Institute. Today is the 6th and final event of Fiduciary September, which features 2 parts. The first, an examination of the state of fiduciary advice 12 years after the Obama administration call for broker-dealers to be held to a fiduciary standard. The second, the awarding of the annual Frankel Fiduciary Prize to former SEC Commissioner Luis A Aguilar. The Frankel Prize is named after Boston University law professor Tamar Frankel. It is awarded annually by the Frankel Fiduciary Prize Selection Committee to individuals whose work in the public and private sectors has made significant contributions to preserving and advancing fiduciary principles in public life. Our first event's discussion will feature remarks from Jason Furman, former chair of the Council of Economic Advisors in the Obama administration from 2013 to 2017. Then we will have a spirited panel discussion featuring Phyllis Borzi, Harold Evensky, Corey Thin, and Keynote Rostad. Phyllis Borzi served as Assistant Secretary for Employee Benefit Security of the U.S. Department of Labor in the Obama administration from 2009 to 2017. As agency head, Borzi oversaw the administration, regulation, and enforcement of Title I of the Employee Retirement Income Security Act of 1974. During her tenure, she was instrumental in leading the charge for the 2016 DOL Conflict of Interest Rule. Prior to serving as Assistant Secretary, Borzi was a research professor at George Washington University Medical Center and was of counsel to the law firm O'Donoghue & O'Donoghue in Washington, D.C. Phyllis Borzi was awarded the Frankel Fiduciary Prize herself by the Institute in 2016, and since 2018 has served on the Institute's Board of Advisors. Harold Evensky is the founder and chairman of Evensky & Katz Folds Financial, a fee-only financial advisory firm, and is a former professor of practice at the Texas Tech University Personal Financial Planning Department. Evensky is an internationally recognized speaker on investment and financial planning issues, and has been a relentless advocate for professional, principle-based fiduciary standards. This has earned him the unofficial title, the Dean of Financial Planning. Prior to forming his own company, he served as a vice president of investment with major investment banking firms. Harold Evensky also was awarded the Frankel Fiduciary Prize by the Institute in 2018 for his outstanding contributions to the fiduciary standard. Corey Thin is general counsel to the Mineta Group, is an agency review member of the Biden-Harris transition team, and previously served 4 years in the Obama administration. During his time at the White House, he served as an attorney, as special assistant to the president, and as leader of the economics team in presidential personnel. Then was a former associate general counsel to Edward Jones and was appointed by President Obama as deputy general counsel of the U.S. Department of Agriculture. Then is an expert on complex legal, regulatory, corporate, and government relation issues. Keynote Rostad is the president and founder of the Institute for the Fiduciary Standard. Before founding the Institute, Rostad served as a regulatory and compliance officer at Rembrandt Pendleton Jackson, a registered investment advisor in Northern Virginia. During the first panel, we invite reporters on the call to submit questions through the chat feature. Please know there will be a recording of the entire event today on the Institute's website shortly after it concludes. And with all that out of the way, I'd like to pass it over to Keynote Rostad. Keynote?
Thank you, Darren, and welcome to everyone who has joined this afternoon. As Darren mentioned, this is the final Fiduciary September program of 2021. And today we take stock of fiduciary advice as we commemorate the 10th year of the Institute. And we also look at and honor Luis Aguilar with the 2021 Frankel Fiduciary Prize. As Darren also noted, we are 12 years since the Obama administration started this round of conversation regarding conduct standards and brokers and advisors in the Treasury paper of June 2019. The Institute launched in 2011 to advance fiduciary principles and advice. Quite straightforward. We set out to be a clear voice for what fiduciary duties mean and why they matter. Our mission is in our words, in our blogs, our papers, our panels, webinars, and conferences. Our vision, I think, can be seen in the voices of scholars and experts that we've also been privileged to have join our programs. In the voice of leading fiduciary advisors, all as well on defending, protecting, and advancing what it is that fiduciaries do. Or, as I like to think of it, in the words of Justice Harlan Fiske Stone, referred to as that principle. The Institute was fortunate at our start. Our first program featured speakers who embodied the importance of fiduciary. In January 2012, we convened a group of over 150 with those attending included at the Museum of American Finance. There we honored the legacy of Vanguard founder John C. Bogle. Paul Volcker and Arthur Levitt headed a program that featured, of all individuals, the current SEC chair Gary Gensler, Yale's David Swenson, Princeton's Alan Blinder, and Burton Malkiel, and our very own, who I think of as our very own today, Professor Emerita Tamar Frankel. These leaders helped advance the fiduciary mission in discussing the Vanguard founder. Their conviction and their candor in their voices informed, engaged, and I think inspired. A common thread of these voices, some form of what we see in the duties of loyalty, care, and utmost good faith. Fiduciary principles are indispensable to secure the health and welfare of and trust in the economy and markets, very much as free speech is indispensable to our democratic principles and to the health of our Constitution. These core principles endure. They are not complicated in our view, and with reference to a certain previously released rule by the SEC, they don't have to be 770 pages. They are set in concrete terms from the Institute in our real fiduciary practices in 5 pages, and are in our ebook Fiduciary Common Sense, which is all of 8 pages. What should advisors and investors understand? Well, for all her scholarly writings, Tamar Frankel boils it down to this, quote, treat others as you would like to be treated. Not a bad way to think about it. The Institute fulfills its mission with a steadfast belief in core ideas. They're not mysterious or unknown. They start with the purposes of the Investment Advisors Act of 1940 and ERISA years later are today more important, we believe, than they were when these laws were enacted. Conflicts of interest, like a deadly virus, should be avoided if possible. This is not my rendition. This actually came from a senior manager at the SEC in 2014, comparing conflicts of interest with the deadly virus. The need to separate sales and fiduciary advice is today as it was then for the framers of the 40 Act, who sought to separate, and what wonderful language they use, tipsters and touts, quote unquote, from real investment counsel. Finally, plain language and guidance and disclosure expressing basic truths and common sense remain vital. And as Chairman Gensler said in May, and I think was his first public statement, public remarks, he spoke about the truth, and quote, the truth matters, unquote. The speakers this afternoon uphold the high standards the Institute set on that winter day in January in New York in 2012. So I invite everyone on today and who listens afterwards to learn and to enjoy and to appreciate the voices that you're hearing. And on that, I will turn it over to Phyllis Borzi to introduce Jay Furman.
Thank you, Keynote. It's my great pleasure and honor today to introduce our keynote speaker, Jason Furman. Jason is an economist and currently the Aetna Professor of the Practice of Economic Policy, jointly at Harvard's Kennedy School and the Department of Economics at Harvard University. He's also a non-resident senior fellow at the Peterson Institute for International Economics. Jason has a long record of public service, and it was during this phase of his life that our paths first crossed. He was part of President Clinton's economic team at the White House But most of you probably remember him best as the top economic advisor to President Obama, serving as chairman of the Council of Economic Advisors, as Darren pointed out, from August 2013 to January 2017. That made him he acted there as both the President Obama's chief economic advisor and a cabinet member. Of course, I was fortunate enough to work with Jason in the Obama administration on pension policy issues generally. Those issues often saw their way into various Obama budget proposals and other policy proposals. And of course, Jason was actively involved in working with us when I was at the Department of Labor on two major initiatives, the 401k fee disclosure project and the conflict of interest definition of fiduciary rule that Keynote talked about a minute ago. You know, in many ways, I regarded Jason as the keeper of the flame on two important Obama goals to protect investors and consumers: transparency and accountability. Jason's portfolio at the White House was very broad, but his insight and his input to the work of all the financial regulators in particular was always both practical and helpful. On a personal basis, he took the time, given all the other responsibilities he had, to focus on our work at the Department of Labor. And I always valued his input and support as we worked on our fiduciary conflict of interest rule over many years. Matter of fact, my career staff would say it took us too many years to get the thing out. So it's a great honor for me today to introduce him and welcome him to this special Fiduciary September 10th anniversary Frankel Prize combined event today, sponsored by the Institute. Jason, we're just so delighted to have you with us. So go ahead. Thank you.
Great. Well, thank you, Phyllis, for that incredible introduction. Thank you, Keynote, for the work that the Institute does on this really important topic. You know, as Phyllis said, I work on just about every economic issue. I worry about exchange rate with China. I worry about, you know, what's going on with inflation. I worry about international corporate tax reform. How do I choose to allocate my time, both when I was in the government and when I was outside it? I look at where there are $100 bills lying on the sidewalk ready to be picked up, or in the case of this issue, maybe even a $17 billion bill lying on the sidewalk waiting to be picked up. I'm a big believer in markets and competition and capitalism, and a big believer that that only works for consumers, for workers, for investors, if there's a certain amount of trust, if there are a set of rules so that the competition is happening based on who has the best quality, who has the lowest prices, and with all of that, then the market can do its magic. I co-teach the introductory economics class at Harvard. And within the second week of the class, we introduced the idea that the age-old economic idea that people are completely rational, completely well-informed, and make always the perfect decision for themselves is not correct in every circumstance. And we go through a test for under what circumstances is it correct and is it not correct. And for the is not correct, one circumstance is if you're making a decision only occasionally, rarely, possibly even one time in your life. Think marriage or rolling your 401k over, two very important decisions that people usually make once in their life. If the decision involves the present versus the future. If on one side of the transaction is someone who actually does that type of transaction every single day and is very sophisticated, and on the other side of the transaction is the person who does it occasionally and who has all of this. This area of retirement savings is perhaps in all of economics one of the areas that's most rife for decisions that can work out really well for people if they make them well, but work out really badly for people if they make them poorly. That's why for many people, advice is so important. And one of the problems in this space is you don't know the motives, you don't know the responsibilities of the person giving you the advice. If all they have is something like a suitability standard, they can basically advise you to do almost anything. The almost anything can result in products that have higher fees for them that amazingly, according to a number of pieces of economic research, don't even have a higher before fee return for you, let alone a higher after fee return for you. And you never know. In fact, it might even be the same institution that one day was acting as a fiduciary for you when you were in your 401k, and the next day changes the basis of its advice as you're rolling out of it. Now, as I said, I try to prioritize my time based on a judgment about the magnitudes that are at stake. When I was chair of the Council of Economic Advisors, we originally did an internal analysis to document how important this issue was. It was designed for the confidential policy process that we had. In my 8 years in government, I think I only can recollect 2 or 3 times when a memo that was an internal deliberative analysis for a policy process made its way out into the public. The memo that my team did, that I led, was one of those 2 or 3 examples in 8 years. It was leaked to a group that didn't like the idea of constraints on the conflicted advice they were giving. I'm not sure I would out them if I remember which group it was, and I don't remember off the top of my head. But it was given, frankly, by someone who, and this is not my experience at government, I think most stuff was exactly like Phyllis described, the way we work together, good faith, trying to understand, work through difficult problems. You could disagree. I don't remember my disagreements with Phyllis. I'm sure there were some. You could agree, and you all work together. Well, in this case, somebody in the process didn't do that. They leaked my memo. My memo got out into the public. It was designed to kill the effort. I think paradoxically, and if I were both Machiavellian and really forward-looking and strategic genius, I might have grasped this and chosen to do it myself. I think it ended up helping the issue because our argument and our analysis, I think, I'm obviously a little bit biased, was compelling. We drew on over a dozen academic studies. A lot of these were very, very careful, published in top journals. This isn't actually a partisan issue. You had people like Kent Smetters, who served in the Bush administration, who felt passionately about this. And so, it's the debate spilled into the public in a way we didn't choose, in a way that we didn't want. But I think in some ways, by having that information out there, it helped drive it forward. We ended up doing more work on it and releasing a report on the issue. We quantified the costs of conflicted advice at $17 billion a year. Just gave an example of how if somebody was at 45 and engaged in a rollover that put them in a high fee product, not even assuming a lower return, that it would likely have gross of the fees prior to considering the fees, and it would be a tax of about 17% on their retirement saving. They chose to continue to withdraw after retirement at the same rate they had before. They would exhaust their funds 5 years earlier than they otherwise would have. If at age 65 you moved into it, then it would be another 12%, and combined you could end up losing 25% of your money to bad advice. So from my perspective, as I was thinking about Chinese currency and inflation and corporate tax reform and everything else, this wasn't just a problem that one should worry about. It was a big one. Of the levers that the government has, that President Biden, the SEC, and others have, other than the laws working their way through Congress, but of the areas where it's a matter of enforcing the existing law, in this case, a law Congress passed in the 1970s, this is among the bigger opportunities to help workers, investors, and consumers that the government has right now. It's a totally, in my view, I'm not a lawyer, legitimate exercise of the protections in ERISA. They themselves stem from the fact that retirement saving is one of the largest government programs in existence. It's what economists call a tax expenditure, but if you take the hundreds of billions of dollars spent on it, the government has an interest. If, by the way, with your own saving outside of the retirement system, you want to make bad choices, that's something that you're free to do. If you're part of what is in effect a several $100 billion government program, a set of protections apply. Now, what about the objections to this? The objections to this, like everything else, are that the sky would fall, no one would get any information again, and it would dramatically reduce retirement saving. Well, some countries like the United Kingdom and Australia did something that was much stronger than anything that was under consideration in the United States. And last I checked, people were still saving for retirement, getting information, and markets were functioning in those two countries. A number of other countries have had variants of this as well. Companies started in the second half of 2016 and the beginning of 2017 to move towards implementing this, and a number of them found it actually was easier and less costly upfront than they thought. Most of the costs are upfront, not something you would have to deal with on an annual basis. And the point of legislation isn't strict cost minimization, it's to maximize net benefits. And in this case, whatever costs there were dramatically outweighed by these benefits. I think this is something that should be done in a simple manner. I really appreciated hearing from Keynote about the 5, 10, whatever number of pages, I think it was single digits, he was talking about. Phyllis got a lot of input from industry. I think on this issue, like most every other industry issue I saw, industry, as powerful as the Fiduciary Institute is, it is probably not the single most powerful player in the space. There are other players in this space with substantially greater resources and interested in protecting their own interests. And so under the standard processes in which administrative matters get dealt with in our government, I think if anything, industry had erred on the side of more input, more flexibility, more safe harbors, more ways to make it easy to comply than erring in the opposite direction. Of course, all of this was halted by the Trump administration. They've now fully restored the status quo ex ante, and that's why it's so important that the Biden administration, the SEC, really focus their attention on this issue. They don't necessarily need to do it this week. They need to keep the government running. They need to handle the debt limit. They need the reconciliation bill and the infrastructure bill. Those are incredibly important. But at some point, all of those will be dealt with, and they'll want to continue to be able to do things for consumers, for workers, and for savers. And I can think of very few things that would be as large and as important as helping people who are faced with a very complicated and confusing decision, and helping them make it in a good, easy, and right way, rather than having a set of conflicts of interest that get in the way of that. This is part of a broader, rethinking of capitalism, of stakeholder capitalism, of the importance of having shareholders, having informed shareholders, having shareholders paying attention to companies, having effective competition that is on the basis of price and quality, not who has the most conflicts of interest and conflicted advice. I heard from a number of financial companies that this was good for them. If they were taking the high road, giving good advice, giving unconflicted advice, this leveled the playing field and enabled them to succeed and thrive in that environment. I think there's no reason any company couldn't comply with this. In fact, many of them already have two hats. They just don't tell you when they're shifting between the two hats. So in conclusion, I wanted to say that I think this is a really important discussion today. I hope it's really listened to. This is an issue where there are interests of 150 million Americans at stake. Most of those 150 million Americans are not attentive to this issue. This is one of many, many things on their plate. When you talk about losing 0.5% or 1% a year, it sounds pretty small. It's hard to understand how much that compounds and grows over time. And that's why the Fiduciary Institute paying attention to this issue, acting as a counterweight to the lower road approach to this, and showing that there's a higher road approach that's consistent with retirement savings, that's consistent with people getting good, high quality advice that they often need, but doing that in a way that has their best interests at heart, is a viable model for capitalism, retirement savings. And I hope you all are persuasive and that this effort gets resumed under the Biden administration. Thank you.
Well, thank you, Jason. That was quite a thorough overview. If you can balance those two concepts of where we have been and perhaps the opportunity ahead. Now to sort of start with the panel discussion. Yes, I think the two overriding questions are sort of where are we in 2021, 12 years after the Obama administration efforts started and 10 years after the Institute launched. And where are we? And then what should we be thinking about how to proceed forward, how to make advancements? And this is largely or predominantly perhaps a regulatory issue, but I think there are other pieces to this as well. So I wanted just to start the conversation with presenting highlights of data that we released last week in a paper. And basically what we did in this paper was pretty straightforward and pretty simple. We looked at 29 of the largest BD's CRS form, their new disclosure form that they're supposed to, in 2 pages, describe what's important on both their broker-dealer side and their investment advisor side. And then we also looked at 12 independent registered investment advisors on their 2-page disclosure form. And what we were looking for here on the RIA side was where and how is fiduciary presented in these disclosures. And what we found, which was a little bit surprising to me, is that when we looked at the dual registration side, the dual registrants, I should say, and looked at the RIA side, of the 29 ones we looked at, only, or I should say 17 do not reference the term fiduciary. 17 of the 29 do not reference the term fiduciary. Of the 11 firms that do reference it, we found that only one of these firms attempts to describe what it means as something different than the broker-dealer suitability standard. So that was interesting on its own account in terms of how the fiduciary issue is handled in this context. But then when we looked at the 12 large independent RIA firms, and these are the firms, from 5 to 30 billion, and so they have compliance resources, and one presumes. And of those firms, and these are the fee-only fiduciary independent RIAs, we found that 7 of the 12 firms do reference their fiduciary status. And of these 7 firms, 3 firms only mention in the context of the broker-dealer standard. And just for a slight moment to get a little bit deep in the trenches, this referencing in terms of the broker-dealer standard, of course, is a demotion for fiduciary, because the required language in CRS to describe the broker-dealer standard is lower, and it's noticeably lower than the traditional fiduciary standard. So, and so what we found from these 12 independent RIA firms, that only 2 of the 12 describe fiduciary as a better standard than the suitability broker-dealer standard. So when I stand back and I look at where are we today in 2021, this is not a hard regulatory analysis in terms of what's happening at DOL or the SEC, but it is a snapshot of how the term fiduciary is being treated by the largest dual registrant firms and the largest, or many of the largest, RIA firms. So I think that is a point that should be part of the discussion. So I'm going to stop there and then hand it over to Harold, Corey, and then Phyllis to sort of offer some opening remarks on the questions at hand. Harold.
Okay, well, you asked to start where we are now. I'd say pretty much the same place we've been for the last decade or so, where the main anti-fiduciary argument is it's going to limit choice. And I'm speaking not as an attorney, not as a politician, not as a regulator, but simply as a longtime financial planner. And in technical terms, I think that would be considered horse pucky and balderdash. I mean, it's just nonsense. There's way too much political and legal nonsense and gobbledygook, including, unfortunately, the term fiduciary, which does not resonate with most investors. I think there's really a simple concept I call the U standard. Someone calls up a broker and asks about a particular stock, and the broker says, well, our research company really likes that stock, and this is why we think it's a good buy. That's a brokerage relationship. And if there's a problem, the buck stops with the client. If the broker, he or she, goes on to say, and I think you should buy that stock, then it becomes a fiduciary relationship. And if there's a problem, the buck stops with the advisor. So it really seems to me like a very simple concept that can be resolved by implementation of what I call the U standard. I think it fits very comfortably with the idea of rebranding fiduciary not as a moral issue, but as a business issue. And again, I remind people that you talked about the 700 plus pages of regulation. The 10 Commandments, they managed to get on a single carved stone. So it doesn't need to be very complicated.
Thank you, Harold. Corey.
Thanks for having me, Keynote. So I feel a bit underqualified to be on this panel with all the luminaries in the field here. But as when you were going through my background, I was in the Obama administration, and after that made a move back to my native Midwest to work for Edward Jones, which, as you all know, is a very large dual registrant. I think they have the most financial advisors in the country. And I was immediately tasked with trying to help the firm interpret and implement the regulation that Phyllis wrote. So I was put on Department of Labor fiduciary rule and later on SEC's Reg BI. And so hopefully I can bring some perspective during the panel of practical on the ground sort of implementation. But at the end of the day, I'm left with the impression that obviously a fiduciary standard is incredibly important. I grew up in a blue collar family in rural Iowa and remember going through my parents' old financial statements where they actually paid not a 6% load on their mutual funds, but 8% load. So Jason's comments very much resonated with me. This is billions of dollars to people who can really use it, right? And I'm also, I had the opportunity to sort of study the history of the brokerage industry and the advice industry and how they've sort of converged over time from effectuating a securities transaction. In the old days, brokers may have simply sold you something and given you access to capital markets that was hard to come by. And eventually sort of, and Edward Jones is sort of where I learned, through their lens, moved up the value chain to the point where it's very clear when you walk into an Edward Jones branch today that you will be receiving investment advice. Now, what standard you'll be under is not clear. If they sell you a mutual fund, you're under the brokerage standard. If they put you in an advisory solutions, essentially a fee-only program, you'll be under the IAA. And I think very few consumers understand that difference. And I think that that's a travesty. And I also think, frankly, from a business perspective, part of what I tried to do during my time at Jones before I left, from Moneta to lead a fee-only legal department, was to convince them that it's actually in their long-term best interest as a business to, support and adopt a fiduciary standard. So with that, I'll kick it over to Phyllis, who knows much more about this topic than myself.
Well, Corey, I think I agree with what Harold said, and I agree with what you said. With respect to what Harold said, in the many, many visits I made to people, members of Congress and their staff on the Hill and people in the industry, I always thought deciding where the line was between fiduciary advice and non-fiduciary advice, while it wasn't easy, it was much easier than the industry would have you think. And I used the exception of the example of the call centers because early on, people in the industry bombarded us at the Labor Department with a request to exempt call centers from the definition of fiduciary. And I said, no. Listen, here's the difference, because they were arguing that the call centers only gave education, only were involved in education, not advice. And I said, now, wait a minute. They may start out in an education mode. You give them scripts, they read the scripts, they tell you the difference, about what you need to know about asset allocation, and they'll explain the investment options. But there is a point in every conversation, whether it's with a call center on the phone, whether it's on an online chat call center, whether you're sitting in a brick and mortar office with somebody. There's a point at which this education moves from education to advice. And Harold is correct. It's the you question. It's not just what would some 55-year-old with this particular, with 3 kids and, 2 are in college and, this, with this risk profile. You're not telling them just what the risk profile is. There comes a point in every one of those conversations where somebody says, where the client says, so what should I do? And it's how you answer that question as to whether you've crossed the line. I have nothing against people in call centers. I have nothing against brokers and insurance agents, etc. Many of them, most of them are probably really good people, and they got into their line of work because they really wanted to help people. And so those are the very kind of people that are not going to want to feel comfortable saying, oh, I can't give you the answer to that question. You know, let me refer you to somebody who's a fiduciary. They're going to try to give you that answer, and then they've crossed the line. So when we approached this task at the Department of Labor, we started with two possible avenues. And Corey, this goes to your experience at Edwin Jones, because I totally agree that this is a great opportunity for the financial services industry, whether it's mutual fund people or, you know, the insurance industry, whatever, to distinguish themselves from their colleagues. But we started with two basic principles. There are only two ways to go here. The SEC, in its lack of delineation under the Investment Advisors Act, has allowed brokers to blur the line between the sales, the transactional part of being a broker, and the advice side. So one way you could go is you could try to make those lines clear again. You could try to create definitional distinctions that perhaps, hopefully, a consumer could understand. We did that in the first round in the rule that we put out in 2010, and it was a disaster because none of the dual hat registrants or the brokers and insurance agents, they didn't want to tell their clients they were only salespeople. So this only other approach is to treat everybody, at least in a basic fashion, like a fiduciary, and then provide exemptions and ways to limit your fiduciary duty under certain circumstances. That's what we did in the second rule that was eventually vacated by the Fifth Circuit. But I've always thought that this was a terrific way that forward-thinking financial institutions could enhance their business. People need advice. I mean, I have a financial advisor. We all need financial advice. And the problem is we don't know who to trust. And this was a way, a mechanism to create a level of trust on a relatively equal footing for all people in the marketplace. So it doesn't surprise me now that the Department of Labor has decided to go forward using the basic structure that the Trump people put out, I guess, last year. And it doesn't surprise me at all that many in the industry have used this year, almost year, to get up to speed in compliance. Some of them have not paid the slightest bit attention. It doesn't surprise me at all that they're busy petitioning the Department of Labor and getting their friends in Congress to urge the department to delay the compliance date because the non-enforcement policy ends on December 20th, 2021.
Thank you. Thank you, Phyllis. To focus on moving forward, Jason, you referenced and Phyllis referenced the opportunity that could be for firms that see this as an opportunity. And I don't disagree with that at all, but I guess what I am wondering is how do you reconcile that with what we have found on the ground troops in terms of the resistance? With 12 years experience and reflection, is there something new that can be embraced to sort of get around that? Part of the frustration from our vantage point was when you listen to the substance of their opposition, there wasn't much to listen to. I think we proved that in that how many people can remember there was any time where there was a civil, what we used to call a debate, a civil conversation where there was a back and forth and we could actually learn something. But I don't remember that happening at all. So anyway, Jason, wonder if you had any thoughts on getting around at least that hurdle of what we saw so much of over the last 12 years, what we've seen so much.
Yeah, I mean, the same challenge is present. which is there's a diffuse interest, tens of millions of people would benefit, and there's a concentrated cost, which is on a very small number of players. The cost is borne, and I think it's a short run cost. I actually don't think it's a medium and long run cost, by people that are respected members in every congressional district in the country, many of whom are well-intentioned. And by the way, if you're super well-intentioned, this probably isn't going to constrain you. So the question is, how do you get those tens of millions of people to speak up? I don't think you're not going to get a mass movement. You're not going to have people marching on the Capitol for this. And with all due respect to this topic, there's probably things outside of the economic sphere that I've worked on that might even be more important for people to march on the Capitol about. But so what can you do? One is if some senators, members of Congress become excited about it, that it becomes hard for the administration to not do it because they'll disappoint key constituencies. There's something strange about this issue because this isn't an anti-capitalist, anti-finance, anti-market idea. This is about how to make markets and investing in the stock market function better. That's why I think it's such a good idea. But so it doesn't, in some ways it doesn't attract the passion of the people who might, that sort of, I don't even want to talk a whole lot about the market and the like. So, but I do think getting some key senators, some key members of Congress, sort of reminding people of who all of those winners are, and in some way they'll notice, and in some way you can describe it. The whole other challenge of getting through the courts. We won a lot of those, but lost a pretty critical one eventually. So structuring it in a legal manner is important too. But ultimately, the nice thing is the Biden administration really gets to decide. When we pulled back in 2010 or 11, it was our choice. I don't know that it was the greatest choice that we made back then, but we then made a different choice a couple of years later, and it's just really is a matter of it's not like President Biden's going to lose his next election because he went forward with this. This is not like a highly politically toxic. It's just a small number of concentrated interests you hear from. You can just move forward.
Yeah. Corey, Harold, any sort of final thoughts as we get to the top of our time slot?
Yeah, I think that just from a practical standpoint, as the brokerage industry sees the success of firms like ours, and certainly Moneta and others, I think they're beginning to catch on that it's a good business model.
Corey?
I couldn't agree with you more, Harold. Phyllis, I think what you kicked off had success, at least what I saw at Jones. They spent $500 million, and they needed to spend a lot of money on upgrading technology, but it was all done in the context of DOL and later Reg BI. And a lot of the things that were put in place, protections on rollovers and things of that nature, we didn't peel those back when the Fifth Circuit struck down the law. And so I think that was a win for investors and their clients. And I think that there is a huge opportunity for the better players to weed out the worst players by embracing a fiduciary standard and marketing it and making it something that consumers actually understand. I do think, if I had a qualm with Reg BI, it does dilute a little bit of, from a marketing perspective, the value that a fee-only firm like Moneta has in being able to say, we're a fiduciary and they're not, and then a consumer who's visited a dual registrant says, well, they said they're operating in our best interest, so what's the difference? And for that reason, I think I would go back to a naming convention, would be one of my regulatory tweaks, if I could wave a magic wand. if you're going to call yourself a financial advisor or anything with the name advice in the title, then you ought to submit to the Advisors Act, and not be able to sort of play this dual registrant game. And, you know, as I've said, I believe that would actually be better for the businesses that do it. So, and it would be better for consumers too.
Well, thank you. We're just at our top of the hour, so I want to thank Jason for his opening remarks, and thank Phyllis and Harold and Corey for their observations. And let's hope that we can go forward. Actually, this is a really quick question, and I bring it up only on occasion. I wonder how each of you look at the changing demographics, just in terms of pure age, in terms of expectations, in terms of how they deal with other consumer decisions when we think of our millennials as opposed to baby boomers. And, you know, just quickly, is that a source of optimism or pessimism or neither in terms of their increasing influence on this issue of getting advice? I wondered, just a quick opinion from each of you. Jason?
In general, just the trend towards, defined contribution plans and the numbers involved should help a little bit, but I don't think it's a game changer, but it's probably a little bit of a tailwind.
Harold?
I would say I'm not super optimistic, confused perhaps, but I don't see a greater awareness in the next generations.
Okay. Phyllis?
I think I agree. I think that there are some millennials that are cause for optimism because they question things more. They ask more questions. And but you know, if you look at the numbers of savings, retirement, they're not good for the younger generations. And it's hard. They're harder to reach.
Yeah. Corey, quick thought.
I don't know if it's a cause for optimism or pessimism, but what I'm seeing when I think about demography is that millennials, despite the talk of robo-advice, actually want a human being to advise them. And so what that tells me is this topic will remain important, that we get this right so that they're going to be well served when they get that advice.
Great. All right. Well, thank you once again, panelists and Jason. And now I don't know what we have to do to sort of switch over to the next group of individuals. Darren, is there anything that we need to do other than say goodbye from the side?
Just turn off your web cameras and your audio, and everyone who's got them off, turn them on.
Great.
Okay.
Wow, we've never moved people in and out of the room so quickly. It's amazing how quickly this can go.
That was great, everybody. All right. Take it away.
All right. Well, I'm going to start with just a brief introduction of the Frankel Fiduciary Award, and then introduce our speakers, and then let our speakers do what they're here to do. So, on that note, the Frankel Fiduciary Prize is in its 9th year. Over the years, the selection committee has sought to identify individuals who have made a special impact on the life of fiduciary. The selection committee, its first year, was chaired by none other than Professor John Coffey, who will speak with us in a few minutes, and I will introduce him shortly. Under Professor Coffey's leadership, our first 2 honorees were Robert Monks and Gary Gensler. That's right. Our first honoree defines what my grandfather used to say was the ultimate compliment, the highest compliment, a gentleman and a scholar. Anybody that knows Bob Monks, I think, agrees that that suits him very well. Our second Fiduciary Prize honoree honoree leads the SEC today, which is a good sign in and of itself, whatever else this individual has. But I should also note that our 5th honoree happens to be Barb Roper. And of course, she is a senior advisor to our 2nd honoree. And so I think that we are well represented in the office of the chair of the Securities and Exchange Commission. And so that is a point that we like to mention when we can do so without bragging, so to speak. And as I say, to say the Institute is proud of this is just a small understatement. Our current selection committee this year is comprised of Clark Blackman, Robert Sitkoff, Michael Koffler, and myself. On behalf of the selection committee and the Institute this year, the honoree will be introduced by Tamar Frankel. And Tamar actually asked me to read her statement to you. I spoke with her literally just 3 hours ago, and she got her flu shot. So she's a little under the weather today. Now, she said she might try to tune in, but she didn't feel like she wanted to be speaking at this event today. So I will start with a sort of very, very quick introduction of Tamar Frankel, and I'm going to do it through another individual that everybody on this screen today certainly knows, and that's Brooksley Bourne. Brooksley was at our first event in December 2013, where we had a dinner the night before at the home of the Dutch ambassador, and she spoke about Tamar. And I'm just going to take a paragraph out of that to introduce Tamar to those who may not know her personally. As Brooksley said, no one embodies those principles of fiduciary better than Tamar herself. She's been teaching, writing, and speaking and researching on the subject for decades and is a leading authority on fiduciary law, regulation, ethics, and behavior. More than 40 years of law school graduates, many of them now leading lawyers, judges, academicians, and government officials, have benefited from her wisdom and guidance. Her books include definitive texts on fiduciary law, regulation of investment managers and investment advisors, and most recently, a timely analysis of Ponzi schemes. Again, this was written in 2013. Perhaps the ultimate in investor fraud is demonstrated by Mr. Madoff. She has played an enormous role in articulating the importance of strengthening and extending the fiduciary standard to a broad range of managers and advisors, ranging from brokers and dealers to corporate directors. Then on a short personal note, she says, I have known Tamar for 48 years and learned early on of her great strengths and talents. As a brand new lawyer at Arnold & Porter in 1965, I met Tamar, an experienced Israeli lawyer who was one of a handful of women lawyers at the firm, and for that matter in Washington. Despite the heavy workload each of us carried, Tamar went out of her way to befriend me. She offered advice and guidance about the practice of law and managing a career as a woman in a male-dominated profession. Her kindness, her patience, and generosity made all the difference to me and helped launch me on a lifetime in a legal profession. She was a wonderful role model and demonstrated the dedication to hard work, scholarship, and courage that has characterized her entire career. I realize today that I was merely one of hundreds of young lawyers and colleagues that she has mentioned and guided and supported along the way. I will pause then, because I think the point that Brooksley sought to make has gotten across, and I thought it would be pertinent to have some short introduction to Tamar in that way. So, with no further ado, I will at this moment read Tamar's statement, which she intended to read herself, regarding the Institute's selection of Luis A Aguilar as the Frankel Fiduciary Honoree of 2021. Quote, "It is my great honor for the Institute for the Fiduciary Standard to offer Commissioner Luis A Aguilar the Frankel Fiduciary Prize. Commissioner Aguilar was appointed to the Securities and Exchange Commission by President George W. Bush in 2008 and reappointed by Barack Obama in 2011. He served until 2015 and became the 8th longest serving commissioner in SEC history. He is one of only 3 commissioners in history to have nominated by 2 presidents from different political parties. Commissioner Aguilar has broad expertise in general corporate and business law and international transactions, investment companies and investment advisors, securities law and corporate finance. He has served on various boards, including the Mexican American Legal Defense and Education Fund, excuse me, Girl Scouts Council of Northwest Georgia, the Georgia Hispanics Bar Association. He has also been very active with national organizations like the National Bar Association, the Hispanic National Bar Association. This enormously varied experience in holding power and service positions did not change the values of Commissioner Aguilar. His expertise, service of trustworthiness, and adherence to fiduciary principles. Many years ago, I came across Commissioner Aguilar in the corridor of the Securities and Exchange Commission. He raised his hand to show me my book on fiduciary law. I have carried this experience with me ever since. He demonstrates that the most powerful people and institutions, including those holding office, holding conflicting views, need reliance on unwavering trustworthiness. This need is not limited to the United States or to people who share ideas and values. Rather, it is a basis for life all over the globe. Thank you, Commissioner Aguilar, for your fiduciary leadership. Statement by Professor Tamar Frankel. Now I'm going to quickly introduce our next 3 speakers and then get out of your way. I will do this in the order that they will be speaking, which of course is not the order that I would normally do it, because this puts the gentlemen before the ladies, but such as it is. Starting with Professor Coffey, a prolific scholar, sought-after speaker, and frequent news commentator. John C. Coffey is an active in several fields and is recognized leading authority on securities law, corporate governance, white-collar crime, complex litigation, and class actions. Coffey has been elected a fellow of the American Academy of Arts and Sciences and is a life fellow of the European Corporate Governance Institute and American Bar Foundation. He has most repeatedly listed by the National Law Journal on its list of 100 most influential lawyers in America. He is also co-author or co-editor of widely used casebooks, including Securities Regulation Cases Materials, the 13th edition. Coffey has served as a reporter to the American Law Institute for the Principles of Corporate Governance, which set forth the fiduciary duties of corporate officers and directors. Coffey's comments on current issues appear frequently in publications, including the New York Times, the Wall Street Journal, and the Financial Times. He is recognized both on the Securities and Exchange Commission and the Delaware Court of Chancery, the forum in which the vast majority of American commercial disputes are heard. At Columbia Law, where he has taught since 1980, Coffey founded and serves on the editorial board, of the CLS Blue Sky blog, where legal scholars and practicing lawyers write on current issues involving the capital markets. Kara M. Stein, as Commissioner of the U.S. Securities and Exchange Commission from August 2013 until January 2019, served as commissioner. Commissioner Stein was appointed by President Barack Obama and confirmed unanimously by the U.S. Senate. While at the commission, Commissioner Stein advocated for strong investor protections and for updating the commission's rules to put investors first. She also raised concerns about the looming retirement crisis and called for the formation of a presidential working group on retirement security. Throughout her tenure at the commission, Commissioner Stein was a strong supporter of the commission's enforcement program and advocated for both companies and individuals to account for violations of federal securities law. Commissioner Stein joined the commission after serving on the senior policy advisor for securities and banking matters to U.S. Senator Jack Reed. From 2009 to 2013, she was staff director for the Securities Insurance and Investment Subcommittee of the U.S. Senate Committee on Banking. Commissioner Stein received her BA from Yale and her JD from Yale Law School. Third, finally, Commissioner Allison Herren Lee was appointed by President Donald Trump to the U.S. Securities and Exchange Commission, unanimously confirmed by the U.S. Senate, and sworn into office on July 8, 2019. Ms. Lee was designated acting chair of the commission by President Joseph R. Biden on January 21st, 2021. Commissioner Lee brings to the SEC over 2 decades of experience as a securities law practitioner. Most recently, she has written, lectured, and taught courses internationally in Spain and Italy on financial regulation and corporate law. Commissioner Lee served for over a decade in various roles in the SEC, including as counsel to Commissioner Kara Stein and as senior counsel to the Division of Enforcement's Complex Financial Investments Unit. In addition, she has served as a special assistant U.S. attorney, was a member of the American Bar Association's former Committee on the Public Company Disclosure, and participated on a U.S. aid project in Armenia. Prior to government service, Commissioner Lee was a partner at Sherman and Howard, focusing on securities, antitrust, and commercial litigation. A member of the Colorado Bar, she holds a bachelor's degree in business from the University of Colorado and JD from the University of Denver College of Law, where she was salutatorian, a chancellor scholar, and served on the law review. So, with those introductions, Professor Coffey, on.
Thank you. First of all, I want to thank you, Newt, for pointing out that I served as chairman of the committee that gave the Frankel Award to Gary Gensler. I take that as proof of my vision and foresight. Unfortunately, it's probably the only evidence of my vision and foresight. So we'll come back to the present time. A biographer could probably write hundreds of pages about Commissioner Aguilar and the glass ceilings he has broken, the battles he's won, the victories he's achieved. I only have 5 minutes, so I'm going to take on a more modest objective, show you that he has been consistently ahead of the curve and ahead of his time. He's advanced ideas and proposals that were new and novel when he first championed them, and now they are part of the mainstream. He'd have even more of these victories if we didn't have a hopelessly dysfunctional Congress, but I won't go further down that avenue. Now, in doing all this, I have reviewed Commissioner Aguilar's speeches during his SEC tenure, which, by the way, was the 8th longest on record, proving that I did do some homework in reading quite a number of speeches to support these conclusions. Now, Luis Aguilar became an SEC commissioner on July 31st, 2008, less than 2 months before Lehman's failure. Now, that's relevant. I'm sure if there were some Fox News commentators here, they would immediately point to a cause and effect relationship. It took him only 2 months to destroy Lehman. But that's not my point, however. My point is that he served during a period that was probably the most exhaustive, even harrowing period in the history of the SEC. It was very difficult just to survive that period, and I was around the scene. I did see it. Some of these scandals, not even Lehman was the worst. It was probably the Bernie Madoff collapse, truly threatened the SEC and truly were probably the most terrifying experience that the SEC went through in its total history. Okay. Now, having reviewed the speeches given by Luis Aguilar, I want to suggest to you that some ideas appear again and again, and he was probably the first person to really raise them in a serious way at the commission. Let me begin with this. The dangers in cybersecurity and the need for boards to give far greater attention to these risks. Today, this is every board's nightmare. He may have been the first commissioner to raise this and to articulate these dangers as a board concern. And he led the SEC to convene the first roundtable on this issue in 2014. Just to show you that I've read his speeches, in a footnote of one, he cites a report by the Department of Homeland Security, which points out that they've recently become aware that some of these cybersecurity terrorists were forcing firms to make ransomware payments anywhere from $100 to $300. Well, that 100 to 300 number, inflation has worked its magic on it, and we're way over that level, but he was raising these issues at the very outset. Issue 2, board diversity, and especially gender diversity. In a 2013 speech, Commissioner Aguilar notes that 54% of the Standard & Poor's 500 companies were now providing workforce diversity data, and he calls upon those firms to reach the 100% level. I don't know if we're getting anywhere near that yet, but I do believe that very soon, when the ESG guidance comes out of the SEC in the next 3 months or so, we will be seeing a lot more data being collected, and this 100% level will very likely be reached with SEC action being the motor force. Point 3, tougher enforcement. In 2012, Commissioner Aguilar endorsed the SEC Penalties Act, which had been drafted by Senators Reid and Grassley, one of the last attempts at bipartisan legislation that the SEC has seen in recent times. Okay, in this speech, he notes he's calling for no-nonsense enforcement. And in this speech, he notes that there have been some recent examples. He gives one involving a major bank that I won't name. It got off with only a $95 million penalty when it was clear that investors had lost over $700 million. Thus, he points out that although the SEC can get disgorgement and can get penalties for Tier 3 violations, those are significant numbers, but nowhere near what the real damages are to investors. And he calls for legislation, such as this, actually called the Strong Enforcement of Civil Penalties Act, under which the SEC should be able to get 3 times the gain and up to the entire loss suffered by investors. Those are tough goals. We haven't got there yet. Someday, I think that's going to remain as a guiding star. We're going to need penalties at that level, or otherwise, corporations will be able to absorb the cost of SEC penalties as the cost of doing business. Okay, 2 more points. Greater cooperation between federal and state regulators. This is a favorite theme for the commissioner. He was a champion of the NASAA, North American Securities Administrators Association, and he protected them and fought for them, and still, I'm sure, believes strongly in them. Lastly, whistleblowers. On the commission, Commissioner Aguilar was a vigorous proponent of whistleblower bounties when others were worried that this would overload the SEC or undermine corporate internal compliance programs. Within the last several weeks, the SEC has passed the $1 billion level in aggregate whistleblower bounties now paid. No new idea in the enforcement field has worked better or nearly as well, and Mr. Aguilar is to be commended for his vision on this score and making sure the SEC stood behind whistleblower bounties. In conclusion, Commissioner Aguilar has championed causes and issues that have become even more important over time. They're not yet fully realized. There still is some work for the commissioners there to consider, but he's shown vision, leadership, and firm commitment, and he justly deserves the Frankel Award. Thank you, and I'll turn it over to the rest of the panel.
Thank you, Professor Coffey. Kara, former Commissioner Kara Stein, the floor.
Thank you, Keynote, for the introduction, and I'm honored to be here this evening on a special occasion, the awarding of the 2021 Tamar Frankel Fiduciary Prize. It's a wonderful way not only to honor her work, but also the folks who have built on her work, like Luis Aguilar. And I'm especially pleased because Luis has been chosen for this honor, and I couldn't think of a more, wonderful person to give the award to, more appropriate person. Luis dedicated over 7 years of his life to public service as a SEC commissioner, and Allison and I both understand what a commitment that is. Luis brought a unique skill set. He had worked in the securities industry for decades on both the buy and the sell side. He'd been general counsel and head of a large global asset manager. And he had also served as the president of an affiliated broker-dealer and the head of the company's Latin America operations. These experiences infused everything that Luis did at the commission, and this practical grounding made him quite persuasive, whether he was talking to a member of Congress, helping decide what to do in an enforcement case, or voting on a rule. But what stands out about Luis is that he didn't come into the commission with an industry bias or industry perspective. In fact, early on in his speeches, he articulated that every decision he would make as a commissioner, he would do through the lens of everyday investors. So Luis came into the commission with this background and basically every day put himself in investors' shoes. And he was always asking whether the proposed course of action was best for investors. He made it clear to everyone, both inside and outside the commission, that that was the job of the commission, to look out for investors. In effect, he made it clear that the commission's clients were investors and the American public, not the securities industry. So from my perspective, Luis, as a commissioner, actually epitomized what it meant to be a fiduciary on behalf of investors in all of their wondrous diversity. And although Luis's speeches and public statements beautifully illustrate his intellectual commitment, and as Professor Coffey mentioned, he was early on advocating for issues that very few people had talked about or advocated for. The thing I wanted to point out about Luis is he also, I think of him as a man of action. So behind the scenes, Luis was forceful, tough, and relentless on behalf of investors. Because of the confidential nature of many of these proceedings that I was engaged with Luis on, I'm not going to regale you with stories, but just let me say, you would not want to get on the wrong side of Luis when he was advocating for what he thought was right, whether it involved one of the 15 or 20 enforcement cases that we voted on each week, or the rules that we negotiated with our fellow commissioners. Luis's actions, and which I think includes also his advocacy and speech after speech, he focused both the industry and Congress on extending the fiduciary duty to broker-dealers providing investment advice to their customers. I remember as the Dodd-Frank bill was sort of being negotiated, it wasn't called the Dodd-Frank bill quite yet, and we were reading speeches from this SEC commissioner who was advocating that there be an extension of the fiduciary duty to broker-dealers giving an investment advice. And he was outspoken and persistent and wrote speech after speech. One of my favorite speeches that he gave in March of 2010, and I really have one sentence in this I really like, but I'm going to read the whole paragraph here. He said, quote, "The fiduciary standard has served advisor clients well for many years, and I believe that it should be the governing standard whenever investment advice is provided. If you're giving advice to an investor, regardless of the title on the business card, you should always be bound to do so in the best interest of the client. While the scope of service may vary between clients, the standards of loyalty and care in providing that service should not." This is the sentence I love. "You simply cannot be 3/4 of a fiduciary." So just wonderful quote. I think Luis himself is like is a full 100% plus, 75% on being a fiduciary. So as many of you know, post being an SEC commissioner, Luis has continued his work on behalf of extending the fiduciary standard to broker-dealers giving investment advice. He has been unwavering in his support for making sure that the fiduciary standard not only, in his own words, is a dynamic living principle that provides investors with true protection, but that it is something that we use both on the broker-dealer side and on the investment advisor side in any place where someone is giving advice to someone about financial matters. So I want to applaud the Institute today for having the wisdom and the foresight, and dare I say prudence, in deciding to award the 2021 Frankel Fiduciary Prize to Luis Aguilar. Luis both has and will continue to make significant contributions to the preservation and the advancement of fiduciary principles in public life, and I'm pleased to be able to speak on his behalf. Thank you very much.
Well, thank you, former Commissioner Stein. I'm biased because you picked out the sentence that I love and remember so well, and I think it was in the context of responding to a certain group who didn't quite understand it. But I love it. It's a great sentence and says so much. So thank you very much. So last but hardly least, Commissioner Allison Lee, the mic is yours.
Thank you, Newt. It's really a pleasure to be here. And listening to the others, I realize my remarks echo them in so many ways because they are right on brand for who Commissioner Luis Aguilar is. I want to share with you my own deep regard and appreciation for his contributions, not just to fiduciary principles, but fundamental principles of public service, which are very similar. And as we all know, as many of you know well, he's an extraordinary man with extraordinary talents. And you can see it from his record, which we've heard plenty about today. I will say first, 7 years of service as an SEC commissioner. As Kara points out, it's a great privilege to serve, as an SEC commissioner, but commissioner years can be not unlike dog years and possibly feel more like 57 years. He's also, as we heard, the recipient of a long list of awards and accolades, and with a collection of firsts to his name. He's been a thought leader on so many important issues, obviously, and importantly, fiduciary duties and fiduciary principles, diversity and inclusion, forced arbitration, issues connected to retail investors, cybersecurity, political spending, at a time when very few were willing to stake out a public position on that issue, and the list goes on. And if you look back through his speeches and public statements, as many of us have, you will find the result of hundreds, if not thousands of hours of painstaking research. You'll find deep analysis, data, attention to detail, and always proposed solutions. I can't count the number of times that I've wrestled with a particular issue and I've asked my counsel to please go and research Luis's prior speeches and statements to help me sort it out. And they are so accustomed to that request from me now that they've learned to anticipate it, and they come to me already armed with the information before I even have to ask. So his record is impressive and it sets him apart even in a field of high achievers. But you know what else sets him apart, and we've heard a little bit of that today as well. It's his dogged, hands-on, unpretentious, and unrelenting approach to the business of policymaking. He has a genuine devotion to principles of fair play, and that is a thread that runs through every single cause that he champions. He's willing to take a stand, even when it's uncomfortable or unpopular, or sometimes even coming at his own expense. He would simply set himself toward a public policy goal and then just press full steam ahead. And I'll share a story. When I was on the staff of the SEC when he first joined as a commissioner, and he set himself apart immediately. There was no pretense about him, no pomp and circumstance, and it was legendary among staff attorneys in the enforcement division where I was that Commissioner Aguilar might just pick up the phone and call you personally if he had a question about your case. He wasn't concerned with rank or protocol. He just wanted to hear your views, and he would engage with people who had good ideas, no matter their position. But make no mistake, the same was true in reverse. If your facts are wrong or your reasoning was specious, you would not be protected by rank from having your arguments dismantled. Kara alluded to that, and it's absolutely right. I would say if you find yourself on the opposite side of an issue from Luis, as my kids might say, you better come correct. Because his goal was always the same. It was to get the best possible outcome for investors, for our capital markets, and for our economy. And he is a rare treasure, and having spent a career placing that goal above all else. I will say that I've tried before, and Luis, you should be forewarned, I will likely try again to lure him back into public service in one way or another, and I cannot think of a more deserving recipient for this award. So thank you for the opportunity to participate today, and thank you, Luis, for your advice and for your encouragement and for the model of public service that you set for us all.
Thank you, Commissioner Lee. What a beautiful remarks. Now, we are at the point in the program where, by the magic of fiduciary powers, we are going to send the physical award to Georgia, and there it is. That I can only think that it's some fiduciary power that lets us do that, but anyway, that is what Louise has received, and with a hearty congratulations from the Institute and from Professor Tamar Frankel, along with everyone else. So, Louise, if you have a couple of thoughts that you want to share, now's the time, and you can go over 5:30. Don't think that we're going to pull the plug at 5:30. But so the floor is yours.
No, thanks, Conrad. If I go too far over, I will have choked myself up, because I expected you guys to say nice words, but you've overshot the mark. And so, I appreciate it. I know for a fact I'm not deserving of so many accolades, but you know what? It's a good day to take them, so I just take them. But I want to thank you for those kind words, and my thanks to the panelists for the earlier presentation, which I thought was good. It is a great honor to receive the Frankel Fiduciary Prize from the Institute of the Fiduciary Standard. The Institute stands apart from other organizations as a strong advocate for principles that underlie being a fiduciary. It's founded on a firm adherence to the principles founded in the Investment Advisors Act of 1940 and ERISA. It does a terrific job at explaining in plain language what this means and why it matters to advisors and ordinary investors, and why it is vital to advancing fiduciary principles. The Institute and Keynote and its supporters have a solid understanding of the foundations that underlie the concept of being a fiduciary, so this award is particularly meaningful. I've been aware of the prize for years, and I've known many of the worthy recipients who received it, all of them incredibly deserving. Some I've been fortunate to know personally, from last year's recipients, Ron Rhodes, to Barbara Roper, Phyllis Borzi, Harold Evensky, and Gary Gensler. but it particularly means a lot to me that the award is named after Professor Tamar Frankel. I belong to that very long list of admirers that have been influenced by her writings. I came across her Regulation of Money Managers treatise in the early 1980s, and I was hooked. Since then, during my legal career and my time at the SEC, I've turned to her writings time and again for guidance, and I've never been disappointed. Professor Frankel has made an indelible impact on supporters of fiduciary principles and anyone who believes in fair treatment. It's indeed an honor for me to receive an award named after her and to join the prior champions of fiduciary who have received it. The fact that her book was always near me made it easy when I heard she was in the building to grab one and go hunt her down. And so I'm glad she remembers that. But it wasn't like I had to go look for her book. It was always at hand. And I'm honored and humbled that Professor Frankel is with us today. And I'm very honored by the participation of Professor Coffey, Commissioner Lee, and Commissioner Stein. It's not lost on me that each one of them is equally, and in fact, truthfully, as they have demonstrated time and time again, more deserving of being recognized for championing the rights of shareholders and investors. Professor Coffey's own writings and scholarly work on securities and corporate law and good corporate governance have informed countless lawyers, regulators, and legislators, and ultimately benefit countless of market participants. And as a former SEC commissioner, I'm particularly grateful for the participation of Commissioners Lee and Stein. No one understands the job better than they do. We've all walked in each other's shoes. We've all gone through the same challenges and opportunities. And I'm delighted that they're both here because I don't want to rank order them, but there's no one better than those two. So I had the pleasure of serving as a commissioner at the same time as Commissioner Stein and have personal experience with her unrelenting support of investors and her courage to do the right thing no matter the consequences. Moreover, as Keynote partly highlighted, Kara has quite a skill for spotting talent and hiring great staff. It's noteworthy that not one, but two current commissioners worked on her staff, Commissioner Lee and Commissioner Crenshaw, two stalwart proponents for investors in their own rights. Now my own awareness of Commissioner Lee, who's had quite an impressive career before becoming a commissioner, started when she was actually on the SEC staff and was involved in cases involving fraudulent misstatements, Ponzi schemes, and other misdeeds. But it was really her time with Commissioner Stein that cemented my respect. Now, great staffs make for effective commissioners. We stand on their shoulders, and anything good that we do is largely true to the fact that we have great staff working long hours and letting us steal half their good ideas. And so I've been grateful to have great staff. But I remember my own staff coming back from discussions with Commissioner Stein's staff, and they were just singing Allison's praises time and time again. And not being shy and knowing that she couldn't sue me since I was a commissioner, we liberally borrowed many of her ideas. And ultimately, it made both Kara and me better to be able to take her ideas and run with it like they were our own. So I thank her for that. Her own term as a commissioner has demonstrated to the public her keen insights into the interaction of federal securities laws and the interconnection with fair, orderly, and efficient markets and capital formation, which are the SEC's mission. But always, this is incredibly important, always with a steady, uncompromising eye on protecting investors. It's her lodestone. It's what she looks for. It's simply part of her core value. Investors can sleep better at night knowing that Allison's on the job. And she's got good colleagues, but I count on her going into their offices when they're not as good as they can. And yes, and I'm talking about Gary Gensler as well too. But yeah, Allison is there, and we can take comfort in that. Each one of these individuals taught me a number of things along the way. But I would be remiss if I didn't also give a shout out to Allison's husband, Jay Brown, a former member of the PCOB, a law school professor, and a great champion of investors in his own right. Long before I think I got to know Allison, Jay was always a phone call away and gave me great advice over the years. So I've been thankful for him. I thought he was a great PCOB member and a great champion of investor. Lastly, I'd be remiss if I didn't thank my own wife, Denise, for being a part of my life. Truthfully, I would not have accomplished much without her in my life and without her love and support. I think that's true of all us. I know Kara's spouse, I know Allison's husband very well, as I just said. Professor Coffey, I'm lacking there with you, but I assume you've got great support staff as well. But I know they do. And I just thank you, Keynote, for this wonderful honor. And I look forward to the day that I'm saying some nice things about some of the colleagues that are here, because they're equal, if not more deserving. So thank you for that. And I think we may have gone only a few minutes over. So
that's fine. Thank you, Louise. Thank you again, Professor Coffey, Commissioner Lee, and former Commissioner Stein. It was really, really great. And so I look forward to getting it up on the website so more people can share this experience. So on that, we will conclude this program and Fiduciary September 2021, and just wait till next year. Just wait till next year. This will be hard to outdo, but we will certainly try. So thank you very much.
thank you all. Thanks, Allison, Kara, Professor, and Keynote.